If there is a judgment against you, there's only three ways to get rid of a judgment in California. I like to say there's three ways to get rid of it. There's a total of 5 possible strategies, and we'll touch on all 3 of those. One that we like to explore first, if possible, is to attack the judgment, typically called a motion to vacate or set aside the judgment. Assumes there's some sort of defect in the securing of the judgment, such as a lack of service or excusable neglect for the reason that you did not respond to the judgment. There are other requirements as well, but if you can successfully attack a judgment, the judgment will be set aside and there'll no longer be a judgment entered against you. Your second option is to settle it. Obviously, if you pay some money, if you pay the judgment or resolve the judgment in some fashion, then the judgment will be resolved when you finish making all of those payments. The third option is bankruptcy. Bankruptcy will eliminate most judgments. It doesn't eliminate student loans or elder abuse or fraud type judgments, but it will eliminate the judgment itself. Special note too, it does not eliminate judgment liens that are already recorded on property. But those are the only 3 ways to get rid of a judgment. Again, that's to attack it and have it set aside, to settle it or pay it, or to file bankruptcy on it. The other 2 pathways that I talk about in terms of how to handle a judgment is wait for it to expire. In California, most judgments are good for 10 years, and therefore it can expire. It can be renewed, so that's not a bulletproof approach. But if a judgment expires, it's no longer valid. It's no longer against you. So if you're at 9.5 years, 6 months, it may expire and you won't have to pay it. The 5th and final option is to what we call the 747 motion, which is to go someplace else, another state, another country. California judgments are only good in California. They are not enforceable in Texas or Florida or New York. It's not bulletproof, however, because a California judgment can be turned into a Texas judgment. So they could chase you to those states, and if they did that successfully, they could enforce it in those states pursuant to those states' enforcement laws. For example, Texas does not have a wage garnishment, so they can't garnish your wages in Texas based on a Texas judgment. But again, those are your 5 pathways to resolving the judgment. Only 3 of them actually get rid of it: bankruptcy, settlement, or attack.